The rights of a spouse. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine State Court Administrative Order PC 581. State Court Administrative Order, SCAO, PC for Probate Court. This form is a confusing form. It's hard for personal representatives to fully understand the scope of their responsibilities when they're administering a deceased probate estate and they're not the spouse. So for example, the personal representative has a responsibility in this form to give notice of the spouse of various rights that they have, whether they want to elect against the will, accept the terms, whether they want to assert their dower rights, exemptions, or allowances under the statute. And that's just a lot of information that thankfully I went to law school and I practice in this area so I understand it. But again, it's a statute that I have to go back and review constantly because the nuances within that statute are very particular. So again, a very confusing form, difficult to understand, but we're going to cover the basics here. With all of the state court administrative order forms, they're guided by court rules and statutes. And as you can see from the floating yellow arrow, I'm identifying the statutes and court rules that are affected or that create or give rise to this particular notice form. So again, read the statutes, understand it, but most importantly, work with a skilled, competent probate practitioner to understand how to fulfill your responsibilities as it relates to this particular form. So remember, this form is being created by the personal representative of a deceased probate estate. It's being created to give notice to the spouse. So again, there's a presumption here that the use of this form is when the personal representative is not the spouse. Otherwise, they'd be giving themselves notice of their own rights. So this is when a personal representative is not a spouse and the notice requirement goes to the spouse. This form is required as part of the larger noticing responsibilities of a personal representative to the interested persons. It must occur under the court rule and statute within 28 days of appointment. So with other reporting requirements of a personal representative, including the notice at the front of the court, notice regarding attorney fees, notice of appointment and duties, these are all forms that I've explained in other videos. This is another reporting requirement, noticing requirement that is an obligation of the personal representative to, in this case, the surviving spouse of the decedent. Now again, dower, which is reflected within this document, only applies to a spouse that was a resident of Michigan. And again, this form and some of the rights of the spouse relate to whether the spouse is still alive at the time that the election would be occurring. So let's work our way through this document for purposes of the personal representative giving notice to a surviving spouse. Top left corner is the county in which the probate case is pending. Top right corner, pretty obvious, the case number for the deceased probate estate. The estate of is simply the name of the estate upon which is being administered. 2 is the section that is identifying the surviving spouse. It's directed to a surviving spouse. So it's giving notice that as surviving spouse of the decedent that's domiciled in Michigan, key words here, because you can open up an estate sometimes in which people are living outside of the state of Michigan. So this is the spouse of a decedent that was domiciled in Michigan. You have the right to elect upon certain rights within the estate. So let's cover one at a time. Number 1, your spouse, in this particular case, left a will. And in the event that that will may have reduced the share that the spouse would have received had there not been a will, or that the spouse may have been disinherited within the will, or maybe the will was created before the marriage and then the spouse survived. So there are a variety of circumstances upon which a spouse may want to take action. Let's just say those again. The will was created before the marriage and didn't contemplate the spouse. The spouse was disinherited in some way, or their share was reduced, or the spouse is given a share that's even less than had there not been a will at all. So this particular section says, as spouse, you can abide by the terms of the will. You have a right to take half of the share you would have received had it gone without a will, which is what we call intestate, reduced by half of the value of the property that you received in other ways. And again, this piece of the statute about calculating which option as a spouse you'd want to take is involved. It requires math, and we want to really analyze all of the assets to understand the decision that needs to be made by the spouse, which occurs within 63 days of the inventory being presented or filed, or after the claims period, 63 days. So there's a time frame upon which the spouse must act. Number two, your spouse left no will, and you have a right to just take your intestate share. And under the laws of intestacy, there are certain formulas, a table that identifies what a spouse will get based on the family makeup. And again, these tables and this process is more involved than just this simple video here, and I'm happy to go through that with you. But the intestate statute dictates, for example, are there children? Are there children that are from the surviving spouse? Are there no children from the surviving spouse? Are there parents, and so on? So again, these are factors that are determined. You have to understand what the person would have as a right as a surviving spouse to take had there been no will under the laws of intestacy. Number three, it says that the election has to be made within 63 days of the presentment of claims. Now, this is the notice of presentment of claims that we've covered in other videos that relate to the publication to unknown creditors and notice to known creditors, and 63 days, or within 63 days after service of the inventory. Now remember, the inventory isn't always filed with the probate court. Often it's presented to the probate court depending on the decision of the personal representative. So you have a time frame upon which to act, and this is giving notice to the surviving spouse of that time frame. And you then have to sign or send an election, and we're going to cover that form in another video. That election is an election of the spouse. So if that notice didn't go out and the spouse just simply sends the election, then the personal representative's responsibilities are satisfied. Under 4, you have the right to priority of what we call the homestead, certain property under the exempt property provision, and the family allowance. These are carve-outs, provisions within Michigan's statute that is, it's like a pecking order. We pay monies out of an estate in certain orders of priority, and the exemptions and allowances, as well as the family allowance, allow for certain monies to be taken off the top before the will dictates and distributes, or before intestate distribution. So again, very involved, very complicated piece of the probate administration, not intuitive. You have to have a real thorough, full understanding of how these statutes play into each other. The personal representative signs this form. If there's an attorney, the attorney information is provided. And the top section is the notice part, the giving notice to the personal representative of their responsibility. The next section is simply the proof that the personal representative has actually sent it out either by mail, first-class mail, registered or certified, or personally delivered it, and the date, and then the signature. So this is a form that has both a notice and a proof of service all within the document. At the Probate Pro, we're passionate about everything probate. If you have questions relating to this notice requirement or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.